Welcome back. I'm attorney Thomas Burton. I'm an estate planning and asset protection attorney here in Wisconsin, and today's topic is the following. One legal document Graham Mertz and every Wisconsin Badger should have during COVID-19. So if you can see today, I'm wearing my Wisconsin Badger tie. The Badger W's are on the tie. It's a little hard to see on camera, but we're excited about a big win over Illinois in the return of Big Ten football this past weekend. However, today as I was driving to work, the news was saying that Wisconsin redshirt quarterback Graham Mertz possibly tested positive for the novel coronavirus COVID-19. And if that's the case, what effect will that have on next weekend's game, etc., etc.? So, well wishes to Graham, regardless of whether he has the virus or not. We hope he gets healthy, and obviously that's a matter for the team to deal with. But what it made me think of today is this topic of one legal document every Badger should have in place. And when I say every Badger, this is a great example of college students who generally are age 18 or older when they begin college. And a lot of times it's one of the first times they leave home, mom and dad, as an adult. So I've covered this topic in the past, but today it made me think, here's a health issue affecting a college student, possibly. And now we know the virus in younger people often isn't fatal, and for Graham we certainly hope that's the case, but any health condition can lead to other health conditions, and you just don't know individual to individual. So thinking about the entire Badgers team, you'll often hear people say everyone should have a will, a last will and testament. Well, I think this is good advice for people who have property or assets. Often people at age 18 don't have a lot of assets in their own name. They may or they may not, so that's up to the individual. But one document everyone has is their own health. Generally, you want to stay alive and stay healthy during your lifetime. So the one document I feel everyone should have in Wisconsin is the Wisconsin Power of Attorney for Healthcare. And I'm holding up here the form from the Wisconsin Department of Health Services. This is actually a statutory form that anyone can go on their website, download, fill out, and sign in front of two witnesses. So if you're watching today and you're a college student or the parent of college students or anyone above the age 18, this is a document you could recommend to your loved one to complete for peace of mind for both them and for you. Because what many people don't realize is in the state of Wisconsin, when you turn age 18, you become what we call an adult, the age of majority in the state of Wisconsin, meaning at age 18, you are no longer a minor. So if your parents made all the healthcare decisions for you while you're under age 18, at age 18, you become in charge. And if you don't have a power of attorney for healthcare in place, you often have no one named to act for you in the event you are incapacitated and unable to act on your own behalf. So a lot of people at 18, I think, assume their parents would take care of them if something happened. In fact, you're often on your parents' insurance, some people until age 26. But the HIPAA laws say they prevent access to your medical records as well. Those are private medical records. And the state of Wisconsin law says once you're age 18, you make your own healthcare decisions. So you can't just rely back on the first 18 years of your life where your parents automatically could take over. So my advice to folks throughout the state of Wisconsin today is if you have one document to put in place during this COVID-19 crisis, consider a Wisconsin Power of Attorney for Healthcare form. And you can get this form free from the state of Wisconsin on the Department of Health Services website. I'll put a link to that in this video. Now, in my estate planning practice at my office, I often help people complete these forms as part of a comprehensive estate planning package. And I recommend you do that whenever possible with a lawyer who can answer your questions and walk you through the form. But I know myself at age 18, I wasn't thinking about estate planning. But thankfully, my mother suggested I fill out this form. So again, if you have a loved one over age 18, you can show them this video and the link to the form. And real quickly today, I'm just going to go through a little bit of the form so you know what decisions you make inside. So the key thing to remember is that after you make the decisions, you have to execute the will in front of 2 witnesses, disinterested witnesses. And the law says they must be at least 18 years of age, not related by blood, marriage, domestic partnership, or adoption, and not directly financially responsible for your health care. So the key thing is, if you pick the witnesses, let's say you name your parent as the agent, you don't want that parent to be a witness on the document, okay? So use someone who is not in the document and who is not responsible for you. It also says a witness cannot be a healthcare provider who is serving you at the time the document is signed, or an employee for the healthcare provider unless the employee is a chaplain or social worker. So this is why I also recommend you don't wait to fill out these documents till you are ill and receiving healthcare, because the law says you can't have the nurse attending to you serve as one of the witnesses. Now there is a way to get the social worker or chaplain if they're available, but it's best to do this while you're healthy and happy outside of the hospital. Now, who may sign? Any individual who is of sound mind and has attained age 18 can voluntarily execute a healthcare power of attorney. An individual for whom an adjudication of incompetence and appointment of a guardian of the person is in effect under Chapter 54 is presumed not to be of sound mind. So, if you don't have a healthcare power of attorney, the alternative is that your loved ones have to go get a court-ordered guardianship to make your healthcare decisions if you're incapacitated. And that's what this is saying. If you're already under a guardianship, you're presumed incompetent. If you've had that adjudication of incompetence, you can't fill one out then. When does this take effect? The power of attorney takes effect upon a finding of incapacity by 2 physicians or a physician and a psychologist as defined in State Statute 44801, or nurse practitioner or physician's assistant who personally examine the principal and sign a statement specifying that the principal has incapacity. So to activate this, you have to have the 2 physicians or the physician and nurse practitioner or psychologist make that statement that you're incapacitated. And now this is new in the state of Wisconsin just this spring, this additional language about allowing a nurse practitioner or a physician assistant to sign, or a psychologist to sign off as well. So if you haven't done a healthcare power of attorney, now's a great time to get the document under the new statutory language and look at your old healthcare power of attorney if you have one in place. Mere old age eccentricity or physical disability, either singly or together, is insufficient to make a finding of incapacity. Okay, so you have to be incapacitated, not just, like they said, an eccentric individual. You remain constitutionally in full control of your health care as long as you are functioning and mentally competent and alert. So when I'm talking about this for football players, for the Badgers team and college students in general, think about if you just get diagnosed with COVID-19 and you're alert and functioning, you remain in charge of your health care. But if you were in a coma or something like that, or had, let's say, a football accident-induced coma, then you need someone to act on your behalf. And that's why I recommend every Badger player should have their parents named, or whoever they choose, a spouse, sibling, as their agent under the healthcare power of attorney. And this story today with Graham Mertz brought it to mind because, again, most college students are over age 18, but they're playing, it's one of their first times away from home, and in the case of the football team, they are playing a sport that can lead to physical complications such as concussions, other things. Now in this case, it's COVID-19 that's currently making this a headline and putting it into the news. But in general, football is a high contact sport and there can be other side effects from playing. So because the Badgers are in Wisconsin, they fall under Wisconsin law. Now, I'm aware some players come from other states and perhaps they executed a healthcare power of attorney at home when they lived in that state. That's a good idea as well, and Wisconsin law would honor that document if presented it. But if you don't have one and you're now residing in Wisconsin, then the best would be to execute the Wisconsin power of attorney for healthcare, because it's likely if you needed treatment, you're going to be treated right at our clinics and hospitals in Wisconsin, possibly even UW Health, right at the university. And this is the form all the doctors, nurses, and healthcare providers are familiar with and by law must follow. So that's when it takes effect. Then the next pages of the document, there's a lot of information about notices and the choice you make inside. And I think we'll save that possibly for a part 2 on this video where I could walk you through the decisions you make inside. But the thing to keep in mind overall, what's important about this document is that you're naming someone else, an individual, an adult over age 18, to act on your behalf only if you're ever incapacitated. And the easiest way to think about this with my clients is think about a coma, because it's a situation where you are alive but you are not able to function and communicate with your healthcare provider like normal. And as you go through life, it's great if you get this in place at age 18. It can cover you for the rest of your life, because remember, the document only needs to be the current document in effect when you sign it, and it will remain valid throughout your lifetime. So today's topic, again, is one legal document every Badger should have in place. And by Badger, I include everyone in Wisconsin over the age 18. I'll put a link to the document below in this video. I hope it's been helpful to you. If it has been helpful, consider giving a like or comment so others can find it out as well. Thank you for watching, and we'll see you next time.